You're good.
You know,
Wherever you're comfortable.
you know how much I love it when you do these things.
It's not even here.
Good morning. Thank you all for making it through our first exciting snowstorm of the season. Right on time. Some people are saying it's early. I think it's right on time. We made it past Halloween, so what more could you ask for? We're going to talk today a little bit about wage and hour pitfalls, some things that we see our clients do as they're growing. We want to make sure that you're set up for growth correctly, so that as you get bigger, you can staff appropriately and not subject yourself to potential liabilities or exposure. So there's 4 big topics that we'll talk about today. The first is the classification of interns versus employees. We'll talk about impermissible payroll deductions, independent contractors, and as opposed to employees, and then how to properly classify your employees as either exempt or non-exempt from minimum wage and overtime requirements.
Exciting.
So exciting. I mean, all this before 8 a.m. So it's kind of getting started. We'll start with interns. I think a lot of companies, as they're growing, they're looking for easy workforce solutions, ways to kind of minimize the cost of labor while they're growing. They think, you know what would be great? We should get an intern, right? Get an intern. It's basically free labor. They're students. We can kind of boss them around. As it turns out, that's not as foolproof as a solution as it might sound to be. So we want to be careful when we're classifying interns as opposed to employees, because we can be subjected to back pay for minimum wage or overtime at 1.5 times any hours, 1.5 times the regular rate for any hours they work over 40 in a work week. Can also owe back taxes, unemployment insurance contributions, workers' compensation insurance, attorney's fees, any benefits that we pay to our employees. All of these can be collected by an intern who's misproperly classified. By an employee who's misproperly classified as an employee. So how do we avoid this risk? As of about 2013, we use what's called the primary beneficiary test to determine whether a worker is an intern or an employee. And if you can believe it, this stems out of a case from Fox Searchlight Pictures. So if you think that the Me Too movement is the only thing that happened out of Hollywood, you're wrong. It started with interns. That was the first movement that we saw. Nobody was paying attention except for me and Todd. Just kidding. So this test under the federal law looks at a number of factors. It's none of them is dispositive, but they'll look at the case or the situation as a whole. And the first thing that the courts will look at is whether there's an expectation of compensation. Obviously, if the intern expects to be paid for their work, that's going to lend itself more to suggesting that there's an employment relationship as opposed to an internship agreement. So if there's any express or implied promise of compensation, more likely the worker will be classified as an employee. Second, the courts or the reviewing agency will look at whether the training that's offered is similar to that given in an educational environment. Does it look like a classroom? Does it look like a clinical setting? What types of hands-on experience is the intern getting? Those are the types of things that they'll look at with respect to training. Also going to look at whether the intern is receiving academic credit or has any corresponding coursework. Is there a class tied to it? Is a university offering training credit or something like that? I will say this tends to be one of the easiest ways, kind of the quick litmus test. You're getting academic credit, much more likely to be classified as an internship, but there should be some type of formal education program or coursework correlated to the internship if it's going to be properly classified. Also look at whether the internship accommodates the academic calendar. Does it correspond with a semester, or are we accommodating the intern's schedule if they're a student to go to class on Fridays or whatever the case may be? We want to be accommodating their academic schedule first and foremost, and looking at the academic calendar taking priority over the needs of the employer. also looks at the duration of the internship. Obviously, a duration that's much more limited is more likely to be classified as an internship, where you have things, or working relationships that are kind of going on for a series of time or indefinitely, much more likely to look like an employment relationship. So again, here, this kind of ties into the last one, but if you have something that runs from September to December, much more likely to be an internship, because again, you're corresponding with the academic calendar. Sixth factor here is whether the intern is complementing the work of paid employees or displacing the work of paid employees. And again here, this is another really significant factor. The DOL, both federally and at the state level, really look at whether you're using employee or interns kind of as a cheat to kind of supplement your workforce. Oh gee, we get busy around the holidays, I know we'll hire a bunch of interns. Really want to avoid that situation. We want to make sure that the intern is getting the benefit of the experience and that we're not just, again, using them for unpaid labor. And finally, under the primary beneficiary test, is there any expectation of a paid job at the end of the internship? It shouldn't be like a trial period where you're automatically hired at the end. It's not a probationary period. It's not a dry run. It really is for a finite period of time. And sure, the intern can make a good impression and perhaps get hired by the company later through their regular recruitment and hiring processes, but it's really shouldn't be an automatic, okay, work as an intern for 3 months and then we'll hire you for sure at the end of that. In this case, the court issued kind of an addendum afterward to make a couple of other comments. The first is that these are always going to be context-specific analyses that we're doing here. It's going to depend on all of the factors. No one of these factors is dispositive. So we're going to look at the program as a whole. And it's important, again, to remember that we're looking at the program as a whole and not each individual intern. It won't be person by person. We want to look at what's been set up more globally. The primary focus of this analysis is what the court calls the economic reality, and that means who's getting the benefit here. If it's the employer, if the employer is receiving work, this is part of their routine operation, the intern is really displacing staff or providing a more cost-effective solution to workforce management, much more likely to be an employment relationship and be likely improperly classified. Where it's the intern that's getting the benefit, they're getting education, they're getting academic credit, they're getting kind of a workforce experience that goes beyond maybe that particular employer. That's much more for the intern. And I think a good way to feel it out is if it's annoying to you, it's more likely to be an internship. If it's convenient for you, it's more likely to be an employment relationship. And so that's kind of your gut check. How do you make sure that you properly classified these folks? I get a question a lot from my clients, particularly those who are in startups or just starting out, they're smaller businesses, and say, well, what if they just volunteer for me? That's not a thing. You can't do that. You can't volunteer for a for-profit business. And there's always like, well, she's my best friend, or, he really likes it. It's helpful for him, or whatever the case is. And as a legal matter, employees cannot waive their rights under the FLSA or the New York labor law. So we want to be very careful about those who we have volunteering for us as we get up off the ground. We see cases like this happen on occasion where, people have an agreement that they just, oh, why don't you, I'll help you out. They decide this at happy hour, they do whatever, I'll help you out, and then something goes terribly wrong, right? Somehow the relationship sours. Thanksgiving's now very uncomfortable for everybody because you have one person suing the other for all their unpaid labor. It's just, it gets messy. I would recommend that we don't do that. Now, there are some additional criteria to consider, and these come from our State Department of Labor after the Second Circuit Court of Appeals, which is a federal court, clarified the standard under federal law. New York said, don't leave us out, we've got more to add on this. So they issued kind of some additional factors that the state DOL looks at. Most of them overlap exactly what we see in the primary beneficiary test, so I'll do you a favor and not repeat them all. But there are a couple of other elements that the state DOL will look at when they're looking at whether an employment relationship is really an intern or an employee. The first is they look at under whose supervision or direction the training is performed. If there's very close supervision, more likely to be an intern. We don't want to leave our interns just kind of doing God knows what. They're inexperienced, they're getting education. We don't trust them like we trust our normal employees. If we're supervising them in a manner similar to our regular employees, going to be probably considered just a regular employee in that situation. The other piece is, does the intern receive benefits? Health insurance is the biggest one, but any other benefits? Are we providing unemployment, workers' compensation, those types of things? If they are receiving those benefits, they're more likely to be considered an employee. And then a big one is whether the training is specific to the industry, or general to the industry, or specific to your particular workplace. If you're training them specifically on your policies, the way you do things, it's very intricate, or it's very specialized to your particular workforce. According to the DOL, this is going to be almost conclusive of an employment relationship. The intern should be gaining skills that are generally applicable in the industry, and not necessarily specific to how you do things or your routine operating practices. We want to look at the screening process. How do you recruit these individuals? If you're using a university or a college or some separate type of recruitment, we want to, again, more likely to be an intern. We want to separate the recruitment processes for interns versus employees. Shouldn't have one job posting and then you get someone and think, could this person be an intern? No, that's not going to work. We want to make sure that our job postings are separate from our recruitment processes, so that we can demonstrate that the searches are separate. And that ties into the next factor, which is how is the program advertised? The DOLs, I don't want to speak for the DOL because they'd probably like silence me forever. So sad. The DOLs, if I could summarize their additional criteria, I think their biggest focus is on what the expectation is. So they don't want someone walking into a working relationship where the person thinks that they're going to be paid, and then they find out when they get way too far into it, oh, this is just an internship or something like that, or where the worker feels like they've lost all power in the situation and doesn't really kind of has gotten too far before they realize, this is only going to be an internship for $5 an hour as opposed to the minimum wage or something like that. So the DOL looks at the screening process, like I said, but also how the program is advertised. We want to avoid the situation where someone thinks they're applying for a job, but really has walked themselves into an unpaid or lower paid internship. The DOL also requires that we notify employees in writing before the internship starts. Again, when you look back at this kind of overarching context that I've just given you, they want to avoid people being blindsided or not realizing. So we have to notify them in writing that it's an unpaid internship and that no wages can be expected. And this is really very similar to what we do with our pay notices, our wage notices now, whereas normally we're issuing a wage notice to employees to say you're getting paid $12 an hour. Here we would say you're getting paid no dollars per hour, but we want to make sure that expectation is given right up at the front.
Could you use that piece of paper and just put zero? Or
Yeah.
Note? You could.
Yeah.
And maybe make a note.
I would say intern, so
just to keep it kind of consistent.
exactly, and then it's just with your regular, just like your normal onboarding practices, it would be the same form, but you want to make sure, but that's a great way to satisfy that requirement. So we want to make sure that we're not depending on the interns in any way, which is a kind of a big piece. Again, if you're depending on the intern, that's going to be more likely to suggest that it's convenient for you and not the burden that I talked about. So if it's convenient for you, if you're depending on them, we want to be careful that we're paying them the minimum wage and overtime and properly classifying them as an employee. Now that's not to say that we can't get any benefit from the internships. Often, some interns are really good, right? Like that's great. And so it doesn't mean that we can't, oh no, you worked as an intern for us, I guess we can never hire you because we really want to be very careful. That's not the way it works. If you have a good intern, they definitely can provide benefit, but we want to look at the program as a whole and generally what's going on there. Similarly, when we look at the recruitment process, we want to make sure that the universities are not kind of handpicking, like, oh, I've got this person, he's really great, shows up on time, seems really smart, why don't you hire him as an intern? If that's the way your recruitment process has kind of taken place, probably more likely that the person's an employee because you're getting a greater benefit in a way. The recruitment process really should be, gosh, we have all these students at U of R who need to fulfill this certain academic credit requirement, or they need this this workforce development component, or whatever the case may be, and you're just kind of taking, I don't want to say anyone, you can have some type of screening process, but it should be much less about kind of their skills. We're supposed to be providing them those skills and helping them understand why it's important to show up early or on time for work, et cetera, things like that. Any questions about that? No? I know, it's very exciting. The second topic we'll talk about are payroll deductions, which are obviously a very convenient way for employers to recoup money that's either that's owed to them in one way or another. Sometimes it's because it's a standard employment practice, and other times maybe there's an overpayment of wages, or maybe we make a loan advance to an employee and things like that. New York has pretty strict rules on what we can permissibly deduct from employee payroll. And there's a whole list that's set forth in the regulations of what we can permissibly deduct. So this includes prepaid legal plans, discounted parking. The biggest one is really going to be healthcare, contributions, things like that. If you have daycare provided on site and you want to deduct for that, of course that works. Gym memberships, this is a lot of the benefit stuff that we see, right? Where an employee wants to take advantage of certain benefits, we can deduct those premiums or costs often from an employee's paycheck. Now, and like I said before, we can also recoup overpayments or advances. I put this one in gray because there are a whole slew of rules that we have to follow if we're going to recoup overpayments or make wage advances. We need to make sure that it's in writing. We have to have an agreement that sets forth the amount, the timing, how long it's going to go on, how many weeks it's going to happen, the amounts that it cannot, that the wage deduction cannot exceed. So we want to be very careful with the one in gray, but generally that's a permissible deduction. The overarching key here is that all of these deductions that are listed are for the benefit of the employee. Again, you'll see here, for the benefit of the employee, not the convenience of the employer. And that's going to be a pretty strict standard, because often we'll say, well, they owe me the money, so it's very convenient for me just to take it out of their paycheck. And the DOL is not going to align with that. It really has to be something that the employee wants, and not the payroll deduction that the employee wants, but it's the reason for the deduction that the employee wants. So if you have I can move to the next slide. So if you provide equipment to the employee when they start work, right? We hire them, and by the way, here are all the tools you need. We have a whole package. It's going to be $250. And guess what? For your convenience, we'll just take $10 a week out of your paycheck. That doesn't work according to the DOL. The DOL says that's really for your convenience. That's so you can get repaid, and not for the benefit of the employee. So it has to, again, be a deduction that the employee is looking for. Yes?
Just a quick question. If you have someone on PFL and then they return back to work,
okay,
and they had
health
regular
insurance.
benefit
Yep.
deductions,
Yep.
do you need a formal agreement to double up on those?
You should notify the employee.
Yes.
Definitely let them know that their
I do.
deduction is going to increase. And what I would do is, before they go out on PFL or FMLA or whatever it is, say,
Yeah.
of course, during those periods, they still owe us the healthcare premiums. We agreed to continue their insurance, and if they are not expected to repay by check or something over their time off, then yes, absolutely, we would say we're going to increase your deduction. That's another key piece, is that all of the deductions that you make, particularly those that are on this slide, must be authorized by the employee in writing. So the employee has to say, yes, I want this deduction, yes, it's for my benefit, and please take it out of my paycheck at X amount. The exception to that is where you have the pre-tax deductions that are authorized by your IRS, or the IRS pre-tax, where we have the cafeteria plans and things like that. If they're authorized in your plan, then that's considered kind of the employee authorization. This is we don't have to get a separate authorization for that. But yours, even though it kind of falls in the middle, it's a little bit different, so I would at least notify them in advance to say your contribution is gonna increase for this period and set forth again the timing, how long that's gonna happen, because really what that is the repayment of a salary advance, right?
Mhm.
That's kind of what you owe us this money, we agreed to front it for you, now we're gonna kind of recoup that payment, so we wanna set all of those factors forth.
Is that true with an FSA? If an employee has an FSA, leaves, like now, has used up their whole FSA for the year, to make it whole. So I have an employee that's resigned that had a $600 for the whole year FSA, $25 a payroll period. So she's leaving. She used up her whole $600 for the year, but has only paid in $500 to the FSA. Can we take that $100 difference out of her last check?
I think we'd have to look at the terms of your plan to see that. Typically, that would be, I'd want to see if it's set forth, whether we could recoup that advance set forth, and whether that's set forth in the plan documents. In theory, we could. At the worst, we could also have her pay it back by check, whether she agrees with that or not is a different situation. But typically in the last paycheck, we have a little bit more flexibility, particularly with respect to repayments of the type that you're talking. If that person hasn't repaid their tools, we advance them the money for the tools, less likely that we can take money out of that last paycheck. But certainly where we're talking about health insurance premiums or anything related to health benefits, we do have a lot more leeway. So I would check the plan documents first, though, just to see what's authorized, and whether there's any prohibitions on doing something like that.
With the person going out on disability or FMLA, and they have health insurance coverage through the company, should we do that form before they leave, or can we just do it when they come back saying, okay?
I would do it before. I would suggest that you try to continue collecting them manually by check if you can, in the event that the employee doesn't return. Just,
right.
And then, but that also creates its own issues, because then if they have non-payment, you cancel their insurance, and then getting them back on the rolls, and blah, blah, blah. There's all sorts of different ways that you can manage that. If you're going to double up their deductions or try to recoup when they return, I would just put it forth before they go out, and then do it again when they get back. You can't ever be too careful about, you can't over-paper this trail, particularly because the deduction laws in New York are so strict. And I think you want employees to understand what's going on, so they don't come back and end up surprised. Or particularly in the case of PFL, where they're getting this money in, and now all of a sudden it's kind of going back out, where they're used to having those deductions automatically be taken. With PFL, where we have the insurance carriers paying a lot of that, sometimes I think there can be confusion, and we want to avoid employee surprise. So if you are authorizing PFL or FMLA or whatever it may be, I would include that in my standard letter to say, by the way, we're going to continue your health insurance premiums, but when you return, we'll be expecting repayment of that. And I would, because it's really a salary advance, I would kind of include that, kind of the authorization in that, to say you agree that when you return, this is going to be your the deduction, and this is how we're going to repay it, and this is how long that will go on. I think that's probably the best practice. But again, when they return, say, just as a reminder, I know your wages were $800 a week before you went out, and this was your deduction, but here's what you can expect for the next 6 weeks or whatever it is.
And same thing if they're out on workers' comp.
Yeah. I would say more so with workers' comp, but that's just my bias. Just because of the lengths of the leave that you could kind of get on with workers' comp. I think we see it a lot more frequently with the health insurance contributions with workers' comp employees, where we end up kind of chasing people around a lot. Again, these are the prohibited deductions. These are expressly set forth in the law as deductions that you cannot make. So we want to be very careful that we're avoiding all of these. Like I said, uniforms, tools, recouping unauthorized expenses, any type of, we can't have penalties for, okay, well, you came in late 5 times this month, I'm going to deduct $20 from your paycheck. We can't have penalties like that. We can't say, oh, your register was short, I'm going to take the difference out of your paycheck. No deductions like that. Political Action Committee, same thing, and interest on employees, the employer's administrative costs. I forgot I did that little thing.
All right. Looks like we got food, so if anybody wants to take a minute and get something to eat or drink, now's probably a good time to do that.
Coffee.
Okay. I'm old, so I'm going to sit down for this. And I'm going to talk about independent contractors, classification of individuals as independent contractors versus employees, and then classification of employees as exempt or non-exempt from the Fair Labor Standards Act. So the independent contractor issue, you know, a lot of employers and a lot of individuals who are classified as independent contractors don't see, you know, why is this a big issue? You know, the person wants to be an independent contractor, they don't want to be an employee, the employer wants them to be an independent contractor, not an employee, so why is this such a big deal? Well, it's a big deal because the government thinks it's a big deal. The government is losing a lot of money because they're not getting the taxes. And these people are not paying into workers' comp, they're not paying into unemployment, and all of those government-supported benefits that employees get that independent contractors don't get. So, as indicated here, governments are losing billions and billions of dollars from people who are being misclassified as independent contractors. So, the state and its various agencies realized several years ago, this is a big problem, and it affects a number of different areas and elements of the government and its benefit programs, like unemployment insurance, workers' compensation, and various different aspects of government-supported employee benefits. So they put together a task force to look at this and coordinate efforts from taxation, from unemployment, from workers' comp, and bring it all together and try to really enforce the requirement that certain individuals be classified as employees. So they've gone to work and they've really put a focus on this, and that's why, obviously, as employers, you need to be focused on this, because the government is really focused on it, and they've put a lot of effort into prosecuting employers for not properly classifying their employees and getting that money back that they're losing in taxes, and employees are losing sometimes in wages because of minimum wage and overtime requirements. All right, so what statutes specifically do we need to think about with regard to this classification issue? Well, obviously taxes. If you're an independent contractor, you're not paying income taxes, you're not paying unemployment insurance taxes, you're not paying into workers' comp and unemployment. Employee benefits plans. This is not necessarily a government-driven thing, but some of the bigger cases in this area have come from people who claim later, after they've left the company, that they should have been covered under employee benefit plans, like stock benefit plans and retirement benefit plans, and they've worked somewhere for 25 or 30 years, and they leave and they don't have any retirement benefit, whereas all these people they worked with who are employees, they have this retirement benefit. So you really have to look very closely at your plan documents with regard to retirement plans in particular to make sure that there's a specific definition of employee versus a non-employee, and then also to classify people appropriately in that regard. And then, of course, payment of minimum wage and overtime. The wage payment statutes apply to employees. They don't apply to independent contractors. So theoretically, if you have people that they're not being classified as employees, then they could be paid less than minimum wage, and it wouldn't be a violation of those statutes. A lot of the discrimination statutes also do not protect employees. They do not protect independent contractors. They primarily protect employees, and there's a definition that you have to apply there. And of course, independent contractors are not allowed to unionize, whereas employees can unionize. So there are a number of different areas in which this definition of employee versus independent contractor is important. And there are a number of different tests that various different government agencies use to determine whether someone is an employee versus an independent contractor. And it's a little bit frustrating because these tests have changed over time. Different government agencies apply different tests, the state, the feds, different agencies within each of those governments applies tests a little bit differently. But I think at the end of the day, you have to really think about it in terms of, is this individual really offering services to other employers, to other companies, and effectively running their own business? That's the way you have to think about it. If you have an employee that's coming in every day to your offices and is supervised by somebody at your business and is effectively acting like an employee, they're an employee. You're the plumber who comes in to fix the pipes when they break, that's an independent contractor. That person either has their own business or they work for another business and they get, they get their employment taxes paid that way. You really, it really doesn't make a lot of sense to play games with these definitions, because all of the government agencies are looking at this very closely. So the IRS test is probably a pretty good one. These various different tests use different words and different language, but a lot of them are very, very similar. So you're looking at who's controlling how this work is being done. Is the individual doing the work deciding how it's going to be done and when it's going to be done, or are they getting specific instructions from somebody else? Are you providing training? Are you paying their expenses? Or are they providing their own equipment and paying for their own expenses, their own computer, their own phone, their own equipment that they might be using to do the work, or whatever it might be? Who's investing in the materials that are necessary to get the work done? Is this person offering services to other employers? Are they, as I said, effectively running their own business? How are you paying this individual? Are you paying them hourly? Are you paying them weekly? Are you paying them by the job? If you're paying somebody by the job, that's more likely to look like an independent contractor, an employee. Does the individual doing the work have the possibility of actually losing money because they're paying for their own expenses, their own materials, or maybe they're hiring even other people to perform the work? So at the end of the day, they could end up losing money. That looks like an independent contractor. Whereas if you're paying somebody's expenses and paying them an hourly rate, for example, that looks more like an employee. Written agreements are important. If you are going to treat somebody as an independent contractor, you need to have a written agreement that specifically says that they're responsible for paying all their taxes, etc. That is not determinative, though. A lot of companies think, well, I have this agreement and it says they're an independent contractor and they want to be an independent contractor and they sign this agreement that says they're an independent contractor. Well, the government doesn't care about that if the other factors are not met. So you're going to need to meet all the factors, but having or enough of the factors to determine independent contractor status aside from this written agreement. How permanent or temporary is the relationship? If it's a permanent, ongoing relationship, somebody's been working for your company for years and years and years, that's unlikely to be an independent contractor in the eyes of the government agencies. And what's the type of work that this individual is performing? Is it the type of work that your employees perform? Is it the type of work that your business is in business to do? Or is it something that just needs to be done, like the pipes need to be fixed? That's not something you're in the business of doing. It's not something that you're in the business of producing, but it's a necessary function that needs to be performed. That is important in terms of the government agency looking at this and saying, well, this looks like employment because this person is just another person that's producing widgets, just like all the other employees, not somebody who's performing some kind of supportive function that's necessary but not part of the actual business purpose. All right, how are you going to minimize the risks? As I said, it doesn't make sense to play games with this. If you think you're close to the line, you really should be treating these individuals as employees, and really only if the person has effectively their own business and is out there selling their services to other employers as well and working for other employers at the same time, then I would suggest that individual be treated as an employee. So you need to look at all your various relationships, anybody who you're looking at as an independent contractor, and assessing all of the various factors that we've talked about. As I said, you have to have an agreement You need to make sure that your employee benefit plans are properly written and you're properly applying them with regard to the distinction between employees and independent contractor. Of course, if you have independent contractors, you're going to be paying them on a 1099. You're not going to be paying them payroll. So you have to issue the proper IRS forms for that. You do not want to be providing equipment, uniforms, tools, etc. to somebody who you would like to treat as an independent contractor. You do not want to have close supervision. You do not want to have somebody reporting to a supervisor at your business every day or on a regular basis. You do not want to require them to come to meetings on a regular basis. They're effectively performing a job that you've assigned to them. They go off and do it when they want to do it and how they want to do it. That's an independent contractor. Yeah, meetings, exclusivity of services. In other words, you don't want them just performing work for you or requiring them only to perform work for you. If you have an employee, it's appropriate and common to say, look, during this period of time while you're working for us, you can't work for anybody else. If you're saying that to somebody you want to treat as an independent contractor, that's a problem. You want them to be performing work for others. And again, the investment, the opportunity for loss, which we talked about. All right, that's it on independent contractor-employee relationship. Any questions about that section?
So
all right.
I
Yes.
have one comment on that. So if you've worked with a professional writer who does work for multiple other firms, not just yours, but it's been a long-term relationship, someone who's done work for you, that's not a employee, is it? They're still employed by others doing that same work, but
Yeah.
after 10 or 15 years, it's not considered a employment contract, is it?
Right. That's not, that in and of itself is not going to create an employment relationship. I mean, you could have the same plumber for 50 years, right?
Right.
So that wouldn't, but it's just one thing that the government agencies are going to look at. If you had somebody that was, coming to your site every day and performing work only for you for 15 years, that
That's
would look
different.
like employment.
Mhm.
As opposed to if somebody came in and did a special project for a week, maybe that's an independent contractor. But that's just one of the factors, and that in and of itself wouldn't sway it one way or the other.
We just went through a unemployment audit, and they do use those 11 factors, definitely. And one of the
Yeah.
other things that they did is, for all the people that were in question, our independent contractors, they went on to, they Googled the business name, to see if they had an actual website.
Yeah.
So that was a big thing too. And are their vehicles lettered, with their business name on it, or do they have a business card, or, so if we could prove that too, and they did, that was a big thing that they looked at. But
Yeah,
then-
you really like to see, if you want to treat somebody as an independent contractor, you like to see that they're effectively running their own business.
Right.
And they're providing services to others, et cetera. And they are really strict about this. I mean, I've been through unemployment insurance hearings where, they go through, they have, and you might have seen this, there's like a 2 or 3 page list of questions, and they ask very detailed questions about what these people are doing and how often are they communicating by email with somebody at the office, and how many meetings do they go to, all those kinds of things, really important. So it's worth it to take a close look at it.
The other piece too is likely, or as a result of the task force, but even before the task force, all the agencies are really sharing this information with each other. So you might be in an unemployment audit and find out that a group of people was improperly classified, and then mysteriously a couple of months later, here comes the workers' comp board, and then here comes the Department of Taxation, whoever it is. So it really spirals very quickly. If you get picked up by one agency, you don't just owe the back taxes or the unpaid wages in the one sentence, you're really gonna have a more global problem.
Yeah, and the other thing that happens is once you realize, well, we've misclassified, then that's always the question, okay, well, now what do we do? Because as soon as you make the change, that raises a lot of questions for this person, like, I mean, the best thing I can come up with usually is to do it, at least to do it at a time of year, like maybe at the beginning of the year, where you can couch it in terms of, we're making some changes at year's end, or, things of that nature. I mean, and there's no way to really avoid it. You're just kind of stopping the bleeding when you make that change. It may end up drawing the attention of the agencies, but it's either that or you're continuing a situation where you have liability building up, and sometimes it's best to just bite the bullet, make the change, and hopefully nobody notices or complains. Okay, now we're going to talk about classification of employees as exempt or non-exempt under the federal and state overtime wage payment laws. This is another area that's getting a lot of scrutiny from the government agencies. And why is that showing like that? Oh, I had to press it again. So there are several requirements that you have to look at to determine whether employees are exempt from the wage payment statutes. One is the salary level. You have to pay employees a certain amount in salary. You have to pay them on a salary basis. We'll get into a little bit more about that. And then there are exempt duties. And this is where a lot of employers have kind of ignored things. They just figure, well, if I pay somebody a salary and it meets the salary level requirement, then they're salary, and they like to be salaried, so that's fine. Nobody cares, and they don't really look at the duties. So we'll go over that. This is another area that plaintiffs' lawyers in private practice have paid a lot of attention to, because it can be very lucrative. You find a group of employees that are misclassified, and next thing you know, you have a class or collective action, and the penalties and liability just multiplies and multiplies over a period under state law of 6 years. You have liquidated damages, so you double whatever you owe that person in overtime, and you're also paying plaintiffs' attorney's fees. So it can be very lucrative for plaintiffs' attorneys to bring these cases, and even if employees are satisfied and happy to be considered exempt, they may not always be that way. Or they may become unhappy for other reasons, like they get fired. They go to the lawyer, they say, I got fired for this and this and this, and it's unfair, and I want to sue my employer. And a lot of times the lawyer will say, well, sorry, but it's employment at will, but how did you get paid? And then they start asking those questions, and that becomes a way for the attorney to bring an action on behalf of that employee and potentially get a lot in liability and back wages. So it's important to look at this, even though you might be in a situation where for years and years, both parties have been perfectly happy to have somebody be an exempt employee. All right, so the salary level test is something that's important to be looking at right now, because it's changing. It's currently $455 a week. You might remember that several years ago, the Obama administration put forth rules that required an increase in the salary level to significantly more than that. They were going to raise it to, I think it was $46,000 or $47,000. That got held up in the courts and ultimately overturned. But now there are new regulations going into effect, which are increasing the federal minimum salary basis to $684 a week. That's about $35,500 a year. And in New York, the salary level is higher and has been for a long time than the federal requirement, and that is also increasing. And to make things complicated, it's also different depending on where somebody works and what they're doing. So downstate, there are different rules or levels for the salary basis, and under state law, there's no minimum salary requirement for the professional exemption. We'll go into what that means. All right. So what does it mean to pay somebody on a salary basis? That means that you have to pay them a regular predetermined amount, regardless of how much they actually work. So somebody leaves work early, you can't deduct that from their pay. They leave work early for a day. Now there are a number of deductions that you can make. If somebody is out sick for a full day, for example, and they've used up all of their sick leave, then you can deduct that full day of pay from the salary. And there's some other exceptions like that, but generally speaking, you have to pay them the same amount, regardless of how much they work during the week. Obviously, it can't be based on hours. Well, you worked more, you worked less, we're going to pay you different amounts. It has to be the same salary on a regular basis. All right, then as I said, there are duties tests, and again, these are often ignored, and they've often been ignored for many, many years. And a lot of employers will say, well, we've been doing this for 30 years, these positions have always been classified as exempt, why should we change? And as I said, unfortunately, these classification issues are receiving a lot more attention from the government agencies and also from plaintiffs' attorneys. So it is a good idea to really look at these, and it's a good time to do it because you may be making changes in any event related to the increase in the salary level requirement. So it's a good time to say, okay, we're making changes. Let's say you look at the duties for a number of employees and you determine, gee, they really don't meet the duties test and probably haven't for the last 20 years. So we should really reclassify. If you can do it in the context of these other changes that are going on, then that's less likely to raise questions for people who are going to say, well, wait a minute, if I'm non-exempt now, why wasn't I non-exempt before? And you want to be able to say, well, we're making a number of changes in connection with the changes in the regulations, and hopefully they don't stop and think that, gee, I didn't meet the duties test for the last 20 years, so I'm going to go after damages for that. All right, so there are 5 general categories of exemptions, and we'll go through just briefly the requirements for each one. The computer is one that we see a lot of litigation over, outside sales, professional, administrative, and executive. So the computer exemption. Essentially, this is somebody who's a computer programmer or systems analyst, somebody who really does computer programming or creates software or analyzes software systems to determine which software is best for a particular networking issue. This is not help desk. This is not somebody that you call and say, I can't figure out what's going on with my computer, my Outlook isn't coming up, and they tell you to reboot. That's not an exempt computer professional.
I want that job.
Yeah, that's, yes. So you really have to look at this closely and make sure that, and a lot of the companies, especially smaller companies, are probably not going to have their own computer professional employee. If you have anybody, it's probably kind of the help desk type of person who's just looking at things and saying, okay, well, this is how you use that particular program, not going into the program itself and making changes in the program. That's a computer professional. The person that just says, oh, click on this, click on that, reboot, whatever, You know, that's not a computer professional employee. Okay, outside sales. The big thing here is that the primary duty has to be making sales away from the employer's business property. That is outside of work, outside sales, not inside sales. And the problem is that this definition hasn't really changed with the times. I mean, a lot of sales can now be done. You know, your email, you're doing WebEx, you can do a lot of those things much easier than you used to be able to do. But the regulation still says you have to customarily and regularly go outside of the business premises and actually meet people to make sales. And unless you're doing that on a regular basis, you know, that means, you know, not just occasionally, but, you know, at least every week you're going out to see clients away from the business premises. You're not outside sales. And that's catching a lot of companies now, because a lot of sales are and can be performed, you know, from work at a computer. And it also applies, by the way, for people who work from home. A lot of salespeople work from home, but if they're sitting at their desk at home, that's not customarily and regularly performing work outside. They might be outside your business premises, but their business premises is actually their house. So they're sitting in their house, they're not outside sales. All right, the learned professional exemption. These are your professional employees, so these are your engineers, people who have to have 4-year degrees, engineers, accountants, lawyers, doctors, some definable professional category of employees that requires a specific 4-year degree. Not just some, you know, you have to have a 4-year degree. That doesn't work. It has to be a specific 4-year degree in a defined profession. Again, like engineering or accounting or something like that. And the person actually has to use those skills learned in the 4-year degree program as part of their job in order to be considered exempt. Just having the degree isn't enough. It has to be a requirement of the job, and actually the skills learned, the education obtained in that 4-year degree program has to be used as part of the performance of the job. The administrative exemption, this is probably one of the ones that employers get wrong most, because it's probably the most commonly used, and that is the administrative exemption. And a lot of companies have just traditionally, over many years, treated employees as exempt administrative employees just because that's always been the way it is. You might have administrative assistants, people that are primarily performing secretarial tasks, but maybe they're working for a high-level employee. Maybe they're working for the president. But what they do is input things on a computer and schedule meetings and things of that nature, and that's not going to cut it, because, as indicated here, the individual has to use discretion and independent judgment as part of their job with regard to matters of significance. So, you know, doing a schedule and deciding whether this meeting should take place on a Wednesday or a Thursday probably is not considered a matter of significance. It has to be discretion and independent judgment related to things like, you know, should we spend $10,000 to order a particular product, or should we order a different product for $8,000 and it's lower quality, or making those types of decisions on a regular basis are a requirement of the administrative exemption, and that's where a lot of companies get caught up. The executive's exemption are your supervisors. These are people who have to manage a particular unit or department. It doesn't have to be, you know, an executive in terms of, well, the CEO. It just has to be somebody who supervises supervises a defined department or unit of people. And they have to, it has to be 2 or more people, and they have to actually perform supervisory functions with regard to these people. That is, they're making decisions or recommending decisions related to hiring and firing. They're doing performance evaluations, they're disciplining these individuals, and they're using their own discretion, or at least using their own discretion, to recommend to somebody at the next level that, for example, somebody be fired, and those recommendations are typically followed. If you satisfy that, then you can meet this the executive exemption. All right, I'm gonna move on and talk a little bit about timekeeping for non-exempts. But are there any questions about classification of employees as exempt, non-exempt under the duties tests that we've been going through?
Do these exemptions have to submit any kind of timekeeping records?
No. You do not have to track hours for exempt employees. Usually want to track, attendance and things like that, but you don't have to record specific hours.
It doesn't mean you shouldn't, it just means you don't have to.
Okay.
Well, if our payroll system pays by hours, we don't need any backup to substantiate that.
No, I mean, a lot of payroll systems, let's say you have an exempt employee that works, they're expected to work 40 hours a week. And a lot of times a payroll system, well, let's say it's a biweekly payroll, it'll just say 80 hours every week.
Right.
That doesn't really mean much. The exempt employees just get paid the same amount, again, regardless of the number of hours they work. Now, if there's an issue later on in which somebody claims, well, gee, I was really non-exempt, would it be nice to be able to show that that person never worked overtime? Yeah, it'd be great. So I guess if you have a position that you're worried about, but you don't want to reclassify, might be nice to figure out a way to determine how many hours that person is working. Because if they're not working overtime, the risk of misclassification is significantly reduced. I mean, that's, the damages are in the overtime. So if you were able to show this person never worked more than 40 hours, you don't have much of an issue.
Or that
Yeah, go ahead.
Or that they only worked 2 hours a week. Like when we're defending cases, employees are always saying, oh, I was working 10 hours of overtime every week, 20 hours. We have a plaintiff right now who says he worked 85 hours every week or something like that. And I'm like, no, you didn't. But you were exempt, so we have no way to really prove that they didn't. So, if the employee is misclassified, it's great if you can show no overtime, but it's also really helpful, even if you can't show no overtime, to say, all right, fine, but you didn't have 10 to 15 hours, you had maybe 3 hours every 14 weeks, and that's going to drive the settlement or the cost of the case and ultimately the settlement value way down, because we can say we have these records. So I'm always telling clients, especially when you're adding a new position, to kind of have them be tracking hours if you can, or there's an easy mechanism to do that, even though they are exempt, just to minimize exposure. People who have been exempt for 15 years, then you come in and say, oh, by the way, I want you to start tracking your time. They'll, best of luck doing that. But where, again, you have a new position coming in, or if you are really unsure, that's a good way to minimize your exposure.
Yeah, and if you come to somebody who's been treated as exempt for a long time, and all of a sudden you're saying, I want you to track your time, that could raise questions for them. Well, wait a minute, I'm supposed to be exempt. Why am I tracking my time? Maybe I should be non-exempt. and then you've caused more of an issue.
Yeah.
So you really have to be careful about making changes in that regard. And you might want to just, if you really think you have a problem with the duties test, again, beginning of next year is a good time to make those changes and just start treating people as non-exempt. All right, so the other big issue that we see with regard to the wage payment laws is non-exempt people whose time is not properly tracked. In order to properly pay people who are non-exempt, of course you have to know how many hours they worked. And there are many, many cases brought in which employees say, well, I worked on a regular basis more time than the employer recorded, or that I recorded on my timesheet. So I worked 42, 43, 44 hours in a week on a regular basis, but I didn't put it on my timesheet, and my employer knew about it. That's liability. And it doesn't matter if the employee did it out of the goodness of their heart, because they're such a devoted employee. They're going to work more hours than you're asking them to, and they're not even going to put it down. They don't care. They're so devoted that they will take their regular 40-hour payment and work 42, 43, 44, 45 hours. If the employer knows that that's happening, the employer is liable. The standard is if the employer suffers or permits an employee to work, it must be paid. So, and that doesn't mean that the president of the company knows. The supervisor knows. So if the supervisor knows that the work is being performed, and the supervisor knows that the employee is not recording the time, that's liability. And that happens all the time. It happens a lot with regard to meal breaks. A lot of employers have unpaid meal breaks, which is fine. If somebody is not working, completely relieved of duties for at least a half hour, that can be unpaid meal break. A lot of employers will automatically deduct that half hour unpaid meal break from the time. So employee punches in the morning, they punch out at the end of the day, and then a half hour is removed by the timekeeping system. That's also okay, as long as you have a system that the employee can report exceptions. The employee can say, I worked through my lunch today, and then you put that half hour back in. You have to have a very clearly defined and clearly communicated system, exception reporting system, in order for that to work. If the employee, what will happen is, years later, the employee will say, well, I worked through my lunch every day. I sat at my desk and I worked, and I ate my sandwich while I worked. If you've been deducting all those half-hour meal periods, that's a real problem. And the only way really to defend that is to be able to say, we didn't have knowledge that this was happening, because we instructed the employees that if they worked through their meal period, that they should report it, and there's an exception reporting system, and that when they did that, we paid them. But even that doesn't work if the supervisor is sitting 2 cubicles down and sees that person eating their lunch every day and working at the computer every day. Again, it's suffered or permitted. So if the supervisor knows that it's happening, the employer is liable. So really, really important to make sure that you have a system for accurately recording time. And you should have a policy in your handbook that says all time worked must be recorded. Off-the-clock work is not permitted. If any manager or supervisor asks a non-exempt employee to work without recording the time, it should be reported to Human Resources immediately. That is helpful not only because it prevents problems going along, because hopefully employees and supervisors understand what they need to do because of that policy, but it also helps you defend cases later on. It helps you say, well, we didn't know this is happening, nor could we reasonably have known, because we relied on the employee to record their time. The supervisor doesn't even work in the same building or isn't in the same office, so the supervisor can't observe. We're relying on the employee to record their time, and we've specifically told them that they must record all of their time. anybody who doesn't record all their time is subject to discipline. You have to be that strict about it, because at the end of the day, the effective burden is on the employer to show you didn't know it was happening if it was happening. And having these policies in writing is very helpful. Best case scenario is to have employees sign off on their timesheet every single week and say, I have thoroughly reviewed this timesheet. These are all of the hours that I have worked, including during any meal periods, and this is an accurate timesheet. If you have employees signing documents like that and signing off on policies like the ones I mentioned, it's a lot easier to defend cases. If you're just relying on some supervisor's testimony, like I didn't know, that's going to make it very difficult. The employee is always going to remember how much they worked, right? And the employer has an obligation to maintain records of hours worked. So it's really important to keep track of that. Questions?
If I employ that at call on the weekend, is there a minimum amount, like an hour that I have to pay for overtime, or?
You have to, there is call-in pay in New York, so they have to be paid at least 4 hours at minimum wage if they're called into work.
No, if I just call with a question on Saturday.
Oh, so they're not coming in?
They're not coming in, I'm just calling them and I need an answer, so it's a 10-minute question.
Yeah, that's something that the regulations and the government agencies haven't really caught up with, at least the last time I looked. They weren't making that distinction of what, and a lot, that happens a lot now, especially, you know, you have a lot of people working remotely, you know, you have people that can do things remotely through the computer, they don't have to come in. But the regulation, the word used is report to work. Are they reporting into work? I mean, I mean, obviously to be safe, you could just make sure they're paid 4 hours at minimum wage. But I think an argument can be made too that the reason behind the requirement is if somebody has to like get up, get dressed, drive it all the way into the office or wherever you're having them work, you should pay them at least 4 hours at minimum wage, right? Because they've gone to all that trouble. You're just calling somebody with a question at home that takes 5 minutes. That's not really the same. So I would say you're probably okay with just paying, you know, whatever the time is that they worked. But that raises another important thing. That is, anybody who's working from home, obviously, that's time worked and needs to be recorded, even though they're not at their usual place of business. And you need to make sure you have specific instructions on that as well.
Are they asking for time to be paid?
Doesn't matter.
So right now.
Doesn't matter.
Exactly.
Be careful on that.
No, I'm just wondering what
Yeah.
prompted the,
Oh, yeah.
No,
the
so
question.
Doesn't matter
Because
if they ask for
Employees
it.
right now, but we are considering making that shift. So I have to be prepared to answer these questions.
Right.
So, you know, hey,
Yeah.
I got a phone call on Saturday.
Definitely needs
Yeah.
to be paid.
In some way.
Probably not with that call-in pay requirement.
Yeah.
And you only have to pay minimum wage, so if they make $20 an hour, you only
You
have to pay
probably are
them.
right anyway.
Yeah.
But you just have to do that. It becomes a pain because you have to do the calculation every
Yes.
week to make sure that, you know, if you add up all the time, all the hours, and based on what they're paid, did they get paid minimum wage for every hour plus the 4 hours that they get for the calling. Other question?
Like, so a lot of this was about like avoiding costly litigation, and I was just wondering for the plaintiff, is it one of those like they pay a hourly fee to the lawyer, or the lawyer just gets a percent, like of whatever the winning or the settlement would be?
It's primarily contingency, which means that they get usually a third of whatever comes in. And for these cases where, you know, there's off the clock work or even a misclassification, that might not be a ton of money for one person. But if you have multiple people misclassified or multiple people who are working off the clock, that's where the plaintiff's attorneys are looking at creating a class or collective action, and you know, it could be, you know, hundreds of thousands of millions of dollars, and they're going to get a third of that at the end of the day. So that's what makes it worth it for them to pursue these cases. And the employees are you know, they don't have to do a lot, honestly. You know, they have to maybe appear for a deposition, and they're gonna get, you know, a fair amount, because if they're successful, because you have to pay liquidated damages, which are equal in amount to the amount that they were underpaid, and then the attorney's fees are paid by the defendant.
Yeah, they're fee shifting statutes, which is unusual, so the plaintiff doesn't really have to pay their own way at all.
What are your percentage of cases, just out of curiosity, where it's more of sour grapes on the employee's part as to a true, not paying people correctly on purpose? Do you know what I'm saying? Do you see more people who are mad they got terminated and now are filing a case because they're saying they never paid overtime, or they're exempt, or do you find that most cases are people who were generally not paid correctly? And
You mean I'll just give you this perspective. A disgruntled employee is a significantly motivating factor for people to file. However, the phrase "no good deed goes unpunished" is like our most frequent. That flies around our office all the time. So there's, and maybe Todd can speak to this as well, but there's a real mix. Often we're trying to do the right thing, or whatever the case may be. And I guess that goes a little bit more when we're talking about the discrimination context, or trying to remediate problems. But it's not a fail-safe to say, well, we were trying to do the right thing.
I would say
It was just a
most
mistake.
employees don't really recognize that they're not being paid correctly, and a lot of people who are classified as exempt like to be exempt. There's like a prestige to it, or they like you to say that they're a salary, not an hourly employee. So they kind of like it until they get fired.
right.
And then they go to the lawyer, and the lawyer starts asking questions, and then they're like, well, how can I get back at this company? Well, that's the way to do it, and at that point they don't care, they've been fired. So I would say that it's fairly rare for an employee, especially in the classification context, to really recognize that they're not properly classified. But a lot of them aren't. I mean, it's just a fact of life. A lot of employees are misclassified, and the company might not realize that they're doing it wrong, but a lot are, and that's a violation of the law, whether you really mean to do it or not. It's not an intent statute. it's
Right.
just whether you're properly paying people.
Did you have a question?
Yeah, so suppose you have a Monday through Friday employee, and they've worked their 40 hours, and then they get called in on Saturday, so they have their 4 hours of call-in pay. Doesn't that have to be a time and a half?
Yeah, those are hours worked, so it has to be paid
So
overtime.
it's-
And you have to figure out the proper regular rate. I mean, if you're paying them the same rate for all of the hours, then it's fairly easy. If you're paying two different rates, then there's, you have to do like a weighted average to figure out what the proper regular rate is, to then pay the time and a half for the 4 hours of overtime. All right. Well, it looks like we're scheduled to end at 9, right?
That's right. Any final question?